Welcome everyone, and thank you for being able to join us at very short notice after probably discovering that you've been accepted into the program yesterday. My name is Alyssa Glass. I'm one of the directors of the program, and Joy Chen is also here. Joy, perhaps just give a wave. You've been receiving lots of emails from Joy, no doubt, regarding your workshop times. Thank you very much. We're really excited about this program this year, and I'll just say at the start that this is our welcome event. Usually we'd be doing this over some drinks, perhaps at Taste, and so it's a little bit different this year, obviously, but we are really, really excited to get to know you and through the program. And thank you. So here for the demonstration Moot, and I'll just ask that if you can keep your videos and audio off as you're joining the call, that would be great. We just don't want to have people popping up on video during the Moot. So we have here 2 Mooters and 3 judges. Usually in a Moot, you'll have 4 speakers, a senior counsel and a junior counsel for each side. Tonight we just have 2 senior counsel, 1 for each side. So I'm presiding on the bench, so I'm the president. Joining me on the bench as the Moot Court of Appeal, which is usually composed of 3 judges, is Angus Nicholas and Henry Cooper. And speaking for the appellant, and you'll hear her give an appearance at the start of the Moot to introduce herself, but I'll also tell you her name now, is Charlotte Lewis. And speaking for the respondent is Joy Chen. So if you, Joy, I'll just ask you, Joy, is the Moot problem was posted on the Facebook event, I think, that's right. So you're welcome to follow along during the Moot if you'd like to take a look at the Moot problem that the participants and the judges, the Mooters and the judges will be discussing. That's on the Facebook event. And there should also, somewhere in your participants guide, no, I don't think there are actually, no written submissions in the participants guide. There are? Oh, okay, Joy tells me there are. So you might even have some written submissions in the participants guide that Joy has sent out to you.
It will be after the problem question, so somewhere around page 15, 16.
All right, so feel free, if you'd like to have a look at the Mooters' written submissions as well to kind of go with the Moot, you can look at that part of your participants guide, but at minimum, the problem at least is on the Facebook event for this call, and for anyone who doesn't have access to Facebook but would like to see the problem after the Moot, we can send that out. All right, well, and I should have introduced you too, Sarah. Sorry, Sarah Purvis is one of the competitions directors. You may know her already, and she's kindly facilitating the Moot and the program, and will be acting as bailiff. Sorry, that's my phone. I'll just see if I can turn that off. I suspect that might have been Chester, Joy. So we will get started with the Moot now. The Moot will be followed by a short Q&A where the Mooters will turn the tables on the judges and ask us some questions. That seems only fair, but you would also be, as participants, the audience members would also be welcome to join in and add some questions just by typing them into the chat. Okay, I think if I can it's just calling on my computer. I might just have to turn my phone off. Apologies, everyone. Yeah, let's try that. So I think that's all. We'll just ask that if your questions in the chat are relate to the idea of the mooting, if there's anything about this Moot that you want to ask, as far as administrative matters related to the program go, if you could direct those to us via email rather than bringing any of those up tonight, that would be great. All right, we'll get started then. So the Moot Court of Appeal is now in session, and we'll take appearances, please.
May it please the court. My name is Miss Lewis, L-E-W-I-S, initial C, and I appear on behalf of the appellant, Ms. Finnegan. I will be speaking for 15 minutes.
Thank you, Ms. Lewis.
Your Honours, my name is Chen, C-H-E-N. I am here on behalf of the respondent, Mr. Ruby Thomas. I'll be speaking for 15 minutes. May it please the court.
Thank you, Ms. Chen. Yes, we'll hear from the appellant now, Ms. Lewis.
Your Honours, this appeal concerns Ms. Finnegan's liability for the false imprisonment of Mr. Thomas in circumstances where Mr. Thomas had been drinking, kept his virtual reality glasses on when looking for an exit, and did not press an emergency escape button until after an extended period of time. Ms. Finnegan appeals from the judgment below on the grounds that, first, Justice Califf erred in finding that Part 6 of the Civil Liability Act 2002 in New South Wales does not apply so as to disentitle the respondent from damages. Second, and in the alternative, even if the Civil Liability Act does not apply, Justice Califf erred in finding that the appellant was liable for false imprisonment on the basis that there was no reasonable means of escape available to the respondent. Turning to my first submission, we submit that the trial judge erred at paragraph 18 of the judgment, where Her Honour found that Part 6 of the Civil Liability Act does not apply. In determining this issue, there are two questions before the court. Does Part 6 of the Civil Liability Act apply? And if so, does it apply such that the respondent is disentitled from damages?
And Ms. Lewis, what are the conditions for Part 6 of the Civil Liability Act to apply?
Your Honour, there are two conditions. One is they're both found in Section 47 of the Act.
Yes.
I will address the first, which is that under subsection 2, that the part does not apply to civil liability that is excluded from the operation of this part by Section 3B. And then the second is found under subsection 1, which I'll address in turn, which is that this part applies to civil liability of any kind for personal injury damages as defined in Part 2 or damage to property.
Thank you.
So as to the exclusionary principle, we must first look at Section 3B as to what the exclusion actually is. And Section 3B provides that the provisions of this Act do not apply in respect of civil liability and awards of damages in those proceedings as follows, and under subsection A, civil liability of a person in respect of an intentional act that is done by a person with intent to cause injury or death.
Well, surely there was an intentional act here.
Yes, Your Honour. And we accept that to the extent Ms. Finnegan closed the door with the intent of leaving Mr. Thomas in the room, that is an intentional act. However, this court must be satisfied of two limbs to determine that Section 3B 1A does exclude of the operation of Part 6. The second limb is whether it is not just merely whether it's an intentional act, but whether it was performed with an intent to cause injury, as was considered by this court in the 2015 decision of White and Johnston, reported in volume 87 of the New South Wales Law Reports, starting at page 779. Your Honours, may we dispense with formal citations?
Yes.
Thank you, Your Honour. So therefore, we submit that it was this second part of the test as to whether there was an intent to cause injury that was not considered by Justice Califf. Contrary to the response—
an element of false imprisonment that there was an intent to cause injury? An element of the tort of false imprisonment?
No, Your Honour. However, it is for the operation of this section. And so there may be circumstances that the person did not intend there to be a false imprisonment, but there still might be other questions as to whether there's a tort. Contrary to the respondent at paragraph 1.1 of their written submissions, we submit that Ms. Finnegan's conduct was not done with intent to cause injury for two reasons. First, Ms. Finnegan did not intend to cause Mr. Thomas stress or anxiety. In fact, she gave evidence at trial that she, and I quote, didn't want to hurt Ruby or cause him any injury. This is at paragraph 13 of the judgment.
Is there some kind of argument that you could make that she was reckless to whether or not it would cause him injury, and that's enough to satisfy this element?
The respondents could put that submission, Your Honour, to the extent that we are looking here at the type of injury. We are saying that she was not intending to cause him any stress, and to that extent we would not say she was reckless in that regard, and that she thought that he would only be momentarily locked in the room so that she would gain a competitive advantage. As to the actual deprivation of his liberty, it is our submission that this is not a relevant type of injury for the purposes of Section 3B(1)(a). There is no governing definition of injury for the purpose of this section, and accordingly the term is to be given its natural and ordinary meaning. The meaning of this term for the purpose of this section has not been authoritatively determined. It was expressly left undecided by this court in the intermediate appeal in New South Wales and Williamson. On appeal to the High Court, the court held at paragraph 34 that false imprisonment, at least to the extent which it sought damages for deprivation of liberty, is not a claim for personal injury damages. There, the High Court was considering Section 11 and did not otherwise comment on Section 3B. However, as suggested in Viller's commentary to the Civil Liability Act, the remarks of Chief Justice French and Justice Hayne do suggest, without definitively determining, that a deprivation of liberty does not fall within the scope of injury under Section 3B(1)(a).
So what do you say that the natural and ordinary meaning of injury is then?
Physical harm or damages to the person's feelings, Your Honour. This would therefore not include the deprivation of their liberty. And this is also consistent with the 2015 Supreme Court decision of Balvin and Thurston, where Justice Wilson defined with intent to cause injury for the purposes of Section 3B(1)(a) as entailing intention to cause anxiety, distress, or fear of physical harm. Thus,
so in your submission, any tort of false imprisonment, any claim would never meet this definition?
Not quite, Your Honour. If it was accompanied by another tort or there was some sort of actionable cause that was related to the false imprisonment, then together it may be excluded. However, in these circumstances, we say that without something further being brought by the respondent, that it would be excluded, or rather would not be excluded from the operation.
Presumably on your definition, if the false imprisonment at the same time caused distress or anxiety, or intentionally caused distress or anxiety, you would say that that would fall within Section 3B, is that correct?
Yes, Your Honour, that would be the case. However, as I previously submitted, we say that Ms. Finnegan did not intend to cause stress or anxiety.
I see. And so if Section 3B, if that exclusionary condition does not apply, then why would Part 6 in fact disentitle Mr. Thomas from damages?
So that goes to the second limb of this question. And so if the court does accept that, then they must consider the operations of sections 48 to 50 of the Act. Justice Califf did not consider these issues as Her Honour considered that Ruby's intoxication was not relevant in the proceedings at paragraph 18. And the respondent accepts at paragraph 1.2.1, the respondent was intoxicated in fact.
So do we as the Court of Appeal have enough information then to determine this issue if it wasn't considered at trial, or should we, if it seems like quite a factual issue, should we simply remit it to the trial judge, say there was an error in that respect, and remit that matter to the trial judge for determination?
There are sufficient facts, Your Honour. We know from paragraph 5 the level of alcohol that was drunk by Mr. Thomas being the 6 to 7 standard drinks. And then we have further facts as to his conduct after the fact while he was in the escape room and his evidence at paragraph 11. This court does have power to consider these factual issues for itself under the Uniform Civil Procedure Rules, Rule 50.16.
So we know he had what, do you include that extra drink then? But when is the relevant point in time for intoxication? He had one more drink in after being locked in the room, did he?
Yes, Your Honour. And the relevant point in time is while he is in the room, once the door has been locked on him.
I see.
Do you have any fallback position whereby there are different periods, it strikes me, to his imprisonment? So you could zero in, for example, on the final 45 minutes after he pressed the emergency exit button. Do you have a fallback position whereby that period is in itself a discrete period if we don't think that there was false imprisonment before then?
To an extent, yes, Your Excellency, Your Honour, in the sense that there might be also a vicarious liability of the 3 broomsticks. However, that is not a submission that we will be pressing today.
Mm-hmm.
The critical question for this court is whether Mr. Thomas was intoxicated to the extent that his capacity to exercise reasonable care and skill was impaired, as required under Section 50, subsection 1, and whether his injuries would not have occurred if he had not been intoxicated, as required under subsection 2.
When you say would not have occurred, to what standard do we need to be satisfied of that?
It would need to be that this is it would need to be satisfied that on the balance of probabilities that this would not have occurred. And I would note that the respondent will submit to you that as the staff were preoccupied at the time, that this injury would still have occurred. To that we respond that at the time that Mr. Thomas pressed the button, this was a far longer period compared to when he was initially locked into the room. At paragraph 12 of the judgment, it states that this was 3 hours and 42 minutes.
We're just losing you, Ms. Lewis. You're just dropping out a little bit. Perhaps if you just pause, come back. At least for me, you are. I don't know about for everyone else.
Is this better? Okay.
Maybe it's
I
me.
think Alyssa might have dropped her connection.
Apologies. Can you hear me now, Ms. Liz?
Yes.
Yes. I think I just had a momentary internet issue. Please continue.
The crux of our submission is that had Mr. Thomas pressed the emergency button at an earlier point in time, the staff of the 3 broomsticks would have been available to let him out of the room, in that the owner, Charlie, was only busy at that point in time because he was helping Ms. Finnegan celebrate her victory, as we know from paragraph 13, and therefore prior to her finishing the escape room, he would not have been occupied. And as for Jane and Janet, it says at paragraph 14 that they were caught up at that point with their green revolution. However, this suggests an escalation, and that if Mr. Thomas had pressed the button sooner, they would have been available to let him out of the room. And so therefore—
Did this court make those kinds of inferences as to factual matters?
Yes, Your Honour, you can. This goes to the fact that this is a rehearing, and as the trial judge did not consider this issue for herself, there is no question of overcoming factual findings by the learned trial judge. And therefore we submit that the respondent is disentitled to damages under the Civil Liability Act. Turning to my second submission, which is that even if the Civil Liability Act does not apply, we submit the alternative that Justice Califf erred in finding that Mr. Thomas had no reasonable means of escape, at paragraph 19 of her judgment. We accept the respondent's submission at paragraph 2.2 that the appellant must satisfy the court that these factual findings are glaringly improbable or contrary to compelling inferences. I will address the 4 reasons given by Her Honour in turn, but the crux of our submission is that there was a reasonable means of escape. In essence, we say that this is to be determined objectively. It's indicated by Lord Justice Aitken's judgment in the English Court of Appeal's 1919 decision of Mearing and Graham White, and affirmed as continuing authority in the Victorian Court of Appeal decision of Macphaenzy and construction forestry. We say that Her Honour, in considering the questions of whether Mr. Thomas knew about the escape button, was not determined, would not go to the objectivity of whether there wasn't a means of escape. And as for paragraph B, we submit that this was merely accepting Mr. Thomas's evidence at paragraph 11 of the judgment, and his perception of the button as small and hard to locate would have been influenced by his intoxication and the fact that he was wearing virtual reality glasses while searching for the button. May it please the court, if there are no further questions, those are the submissions for the appellant.
Thank you, Ms. Lewis. And I apologise to you that I lost connectivity for a moment. Hopefully that won't happen again. And if my fellow judges are ready, I'll just wait one moment. Yes, and all right, we'll hear from the respondent then, please.
May it please the court. This appeal concerns my client's right to liberty and his entitlement to compensation for being locked in a room for over 4 hours. In response to the appellant's 2 grounds of appeal, we make 2 submissions. First, we submit that the trial judge was correct to find that Part 6 of the CLA, which relates to intoxication, does not apply. And second, we submit that this court should not overturn the factual findings by Her Honour that there was no reasonable means of escape, because those findings are neither glaringly improbable or contrary to compelling inferences. Now, turning to the first ground of appeal, our primary submission here is that Part 6 of the CLA does not apply. However, in response to my learned friend's submissions, we will make the alternate argument that even if Part 6 were to apply, my client's right to compensation is not precluded by Section 50 of the CLA. Turning then to that primary submission, here, as my learned friend noted, for Part 6 to apply, the 2 requirements under Section 47 must be met. I will address the requirements under Section 47, subsection 2 first, to mirror my learned friend's submissions. Part 6 applies if liability isn't excluded by Section 3B(1)(a).
Ms. Chen, how can you defend the trial judge's reasoning at paragraph 18 that the Civil Liability Act simply does not apply to intentional torts? Her Honour doesn't appear to have even referred to the test in Section 3B of that double intent requirement. Isn't that just plainly contrary to a whole series of this court's decisions, emphasising that there's 2 limbs there to Section 3B?
Your Honour, we do note that the trial judge doesn't refer specifically to that test. However, that does not necessarily mean Her Honour's conclusion, which is that where Her Honour said, and in particular, quote, Part 6 does not apply, that finding is immediately incorrect, because as our submission will demonstrate, that is a finding that is correct in law. So turning to that legal question, that first element requires that liability is not excluded by Section 3B(1)(a). And as my learned friend pointed out, the key question here is whether or not the appellant, in closing the door behind her in that first escape room, intended to cause my client injury. It is
is your strongest submission really the second submission that you make, that this is not a claim for personal injury?
We submit that both submissions are strong, Your Honour. However, I can turn to that to address it first, because indeed, to succeed, my learned friend would have had to satisfy this court that both conditions under Section 47, both subsection 1 and subsection 2, are met. The condition under Section 2 is that this be a claim for personal injury damages, and that is defined in Section 11 of the CLA as damages that relate to death of or injury of a person. we submit that that condition is not met here. And to clarify, the term injury does come up in both submissions under subsection 1 and 2 of section 47. However, the use of injury here under subsection 1 is in relation to section 11 of the Civil Liability Act. And that, as this court said in 2005 in the case of New South Wales and Ibbett, is a much narrower concept than the notion of injury under section 3B1A. The term, and so whilst my submission is that my client's deprivation of liberty is sufficient to satisfy the meaning of injury under 3B1A, that is not necessarily so under section 11.
Can I just clarify? So is your submission that Ms. Finnegan intended to cause injury, but the claim is not for personal injury damages? Is that the two parts of the submission?
Not quite, Your Honour. Our submission is that under 3B1A, the term, what we say is injury, is the mere fact of a deprivation of liberty. So under that first part of the submission, our submission is that the appellant did intend to deprive my client of his liberty and therefore cause injury within the meaning of section 3B1A. However, that injury does not amount to personal injury damages as defined in section 11. As this court, I withdraw that, Your Honours, as the High Court said in the 2012 case of Wellington, New South Wales and Wellington, the mere deprivation of liberty does not rise to the meaning of injury under section 11. And that is the question under this part of the submission. So whilst something like psychiatric illness would suffice for section 11,
that's taking an obvious case, but what about something less than psychiatric illness, but more than mere deprivation of injury, so of liberty? So we know that Mr. Thomas felt really trapped and quite panicked. That's at paragraph 11 of the judgment. Is that not sufficient? Is that not impairment of his mental condition?
On our submission, no, Your Honour, because in the case of New South Wales and Wellington, the High Court said that injuries such as harm to reputation or loss of dignity, those types of emotional reactions, emotional injuries, that is not sufficient to satisfy the section 11 definition.
But damage to a reputation is not necessarily emotional. There is impairment of a mental condition, is there not, when there's panic?
On our submission, not necessarily on that, and in particular on the present facts. In those initial 2 hours when my client was in the room, he was not necessarily feeling that amount of panic. It was only much later on where that emotion had set in. And so...
Can I also ask, is a part of your submission, you can say whether you accept this or not, do you put it that the distress and the panic that the plaintiff felt was not impairment of the mind because it was the normal reaction to a person in a situation like this? Could you ever have an impairment to someone's mental state when it's simply the normal reaction to circumstances put to them?
We would embrace that point, Your Honour. Indeed. And in that sense, therefore, there is no personal injury damages, because here the injury that my client suffered did not rise to that level. And therefore, we submit that this requirement under section 47, which is a threshold requirement for the application of part 6 of the CLA, is not established. We do note that that is our primary submission. However, in response to my learned friend, we also put the alternate submission that even if part 6 of the CLA were to apply, section 50 does not exclude my clients from his entitlement to compensation. Now, my learned friend turned to section 50, subsection 1 of the CLA, that requires that my client was both intoxicated and also intoxicated to the extent that his reasonable care and skill was impaired. Now, we acknowledge that my client did consume alcohol, and therefore we do not contest the point that he falls within the Section 48 definition of intoxicated. However, we say he was not so intoxicated that his reasonable care and skill was impaired.
Does it depend does the definition of impairing reasonable care and skill depend what you're doing? So for example, could you say his reasonable care and skill in driving a car would have been impaired, but not in running through an escape room, fighting dragons or whatever he was doing?
Yes, Your Honour, that is exactly the case, and that is what President Alsop said in the 2011 case of this court, Amanda on the Edge Proprietary Limited and Dries. In that case, it involved the plaintiff who had a few drinks at a wedding and was leaving the venue and walking to his car at night. President Alsop said in that case that the circumstances there are relevant. That plaintiff was not driving a car or operating heavy machinery, and therefore the amount of care and skill expected of him, which is as he was walking across an open car park, was much less than, say, someone who is driving a car. And we say here, as Your Honour Justice Glass noted, that the activity that my client was doing was participating in a make-believe escape room that was hosted in a pub, probably in a situation where most participants would be expected to have had a few drinks. And we say in that context, the amount of drinks that my client had did not impair his reasonable care and skill.
Well, surely it did, in the sense that he didn't even take off his virtual reality glasses whilst trying to find a way to leave the room. That seems like quite a straightforward example of reasonable care and skill being impaired.
We acknowledge, Your Honour, that my client did keep his virtual reality glasses on for 2 hours. However, we submit that the reason for that is not necessarily because he was intoxicated to such an extent that he couldn't take it off. It was rather that he believed that the appellant, his friend, would come and rescue him from this room, and that therefore there was no sense of urgency for him to take off those reality glasses in order to start looking for a way out. Indeed,
can I also ask a question? Sorry to interrupt you, about the context. It's quite striking that the context of this is happening in an escape room, where the nature of it is that people consent to being put in a situation where they just can't get out. Why wouldn't the court hold that your client consented to this deprivation of liberty?
We submit that this game of an escape room is quite a common phenomenon now, and by definition, in participating in it, he did consent to an extent to be put in that room. However, he did not consent to being put in a situation where there is no reasonable escape at all. He did not consent to be put in a situation where the only method of escape, which was this escape button, would be faulty and therefore actually not work and keep him trapped in that room. And therefore, we submit that in general, my client, whilst intoxicated, was not intoxicated to such an extent that his reasonable care and skill was impaired. And turning to the second requirement under Section 50, subsection 2, which is that we submit that this deprivation of liberty was likely, even if my client was not intoxicated. Referring back to my earlier submission about those first 2 hours in that room, that it was attributable to the fact that that the lack of urgency was because he trusted his friend and believed she would come and rescue him, rather than his intoxication. Because indeed, once he did take off his virtual reality glasses, he was able to find a button that Her Honour, Justice Califf, described as both small and difficult to find in 30 minutes. So
is this informed by our finding as to your previous submission on the effect of his intoxication? So that if we find that he was intoxicated and to the extent that his capacity to exercise reasonable care and skill was impaired, it makes the presence of the button a more reasonable means of escape, because we discount the factor that you're relying on now about this 2-hour period being reasonable to wait for, and it was reasonable to keep the glasses on. So are those two things linked?
To clarify your Honour's question, are you asking whether our submissions under section 50 subsection 1 is related to? So we accept that as the respondent, we will need to demonstrate that both the conditions under subsection 1 and 2 of section 50 are not met. So if, for example, your Honours find against us on subsection 1 of section 50, then the appellant has succeeded under this submission. And so therefore, as we move on to subsection 2, Your Honours, I note that my time has expired. Justice Glass may have a 1-minute extension to quickly complete my submissions.
Again, being concerning, but if you can hear me, then yes, you may have an extension.
Thank you, Your Honour. I will quickly address my second submission on the second round of appeal. We note here that the primary question is whether or not the primary judge's factual findings that there was no reasonable means of escape should be overturned. And the High Court said in 2003 that a trial judge's findings of fact should only be overturned if it is glaringly improbable or contrary to compelling inferences. We submit that it is not, and we submit that my learned friend has not discharged the burden to demonstrate that degree of error. The thrust of my learned friend's submissions is that if my client had pressed the button earlier, he would have been let out, because the people who were manning the button and the surveillance would have been still around rather than in an environmental protest to let him out. However, that is besides the point. The button in saying press to exit in emergency represented that once pressed, my client would be released. That was a false representation, and there was no other way to get out. And therefore, there was no reasonable means of escape, and Her Honour's factual findings should be upheld. If there are no further questions, Your Honours, that concludes my submissions. May it please the Court.
That also concludes the moot. I'll just apologise to everyone for my internet connection, which of course I've never had any difficulties with until tonight, and that's just fitting, but I've now swapped networks, so hopefully that's over for this evening. I'd like to thank Joy and Charlotte for their submissions. What we'll do now is I'll just invite Angus and Henry to make any brief comments on the moot, and then we'll turn to the Q&A part of this evening's proceedings. Angus, did you have anything you wanted to comment on from the moot?
Not much to say. I thought that was really good, and thank you, Charlotte and Joy, for doing that. I thought it was a well-written question and very well argued. If I had to point out particular things, Charlotte, I think that you started really well. I liked your introduction because you just stated a few facts that were relevant, that favourable to your case, and that's perfect way to start a moot. And I also thought it was great how clear you were in your signposting and structuring your submissions. I was never really confused where you were up to or what point you were making. Joy, I really thought you had a really great responsive structure, which is perfect for a respondent. So every submission that you made, you phrased it as responding to an argument that Charlotte made, and you mirrored your submissions to hers. And I think that's a really good skill for a respondent to adopt. So yeah, I thought it was great.
Thank you. And Henry?
I agree with what Angus just said. I think that was a very high standard moot, which was completely appropriate for a demonstration moot. That's something that anyone watching can aspire to. In terms of pointing out some really good things that both of you did, you both, and this is something that everyone watching should also aspire to, set out the structure really clearly at the start of what you're going to say. So the judge just knows exactly what's coming and knows where you are throughout your submissions. You'll notice one thing that Charlotte did was ask for permission to dispense with formal citations. That's a convention that people follow at this law school, so that's something that you should all do if you're the first person speaking in a moot. That's something you have to do. A good thing that Charlotte did as well as the appellant was to engage with the written submissions of Joy, because that's one of the things you're marked on, is your ability to engage with the other side. And as the appellant, that's all you can really engage with. So I think Charlotte pointed to specific submissions and paragraphs of the submissions. That's a really sort of high level skill that you should try and do if you're going to do really well. Charlotte dealt well with internet connection issues, which is a new Mooting challenge, which you might have to deal with this semester. I think that was really good. And one thing that Joy did well as well was kind of moving around based on hints from the bench. Like I sort of took her to a second submission first, and she was very comfortable moving to the second one. You'll get that a lot. I think judges sort of either explicitly asking you to address something else or strongly hinting that they're not interested in the submission you're trying to make and suggesting that you go to another submission. It's really good to be as flexible as you possibly can and ready to move throughout different submissions. Yeah, but no, it was really excellent, and thank you for taking the time to prepare for it. It was really good.
I echo those comments, and I'll just add just a few things. I think one thing that's useful to notice is the style in answering questions. So both Mooters, but Charlotte, you did this particularly, used yes and no answers at the start to great effect, and also flagged where the question answer linked back to their submissions, and were able to use the questions to move them through their submissions. So that's quite a high level skill to have. And I think, what was the other thing I was going to say? Joy asked for a time extension in a very prompt manner, so that's great, and obviously shortened. Both had to shorten their second submission when that was necessary, and I think we're able to adapt quite flexibly, as Henry said, to the questions from the bench. So well done, and thank you. I'll just ask now if we could perhaps, and I'll give you a little bit more introduction for those of you watching who don't know us. We're just going to tell you a little bit about ourselves and have a bit of a chat about why we think doing this mooting matters and what we learnt from our time mooting at law school. So I'll start. So I did the JD at Sydney Uni between 2015 and 2017. I didn't do that much internal mooting. I think when you do a JD, you don't necessarily have a lot of time to kind of do lots of internal mooting, I suppose. I did the first year moot though. No, the torts moot. And after that, I think I did the QUT torts moot, which is an intervarsity or national moot. And that was a wonderful experience to work in a team and to get coached by an extremely expert coach, of course. And I then went on after that to apply for Jessup and to do the Jessup moot. And since leaving law school, I have worked at the courts and gone overseas and done a master's at Oxford. And now I'm heading very shortly to go and work at a law firm in Paris as a solicitor there. So Angus, would you like to perhaps give a brief overview of your mooting experience and where you're at now?
Yep. So I did the LLB from 2011 until 2016. And as Alyssa said, that kind of gives you the advantage. You have longer to moot. So I started with the torts moot as well in 2012. and then also did the QUT moot after that, and that kind of snowballed. Kept doing as many moots as I could, really. And then eventually in 2015, I did Jessup, and then was lucky enough to kind of move more into a coaching role from there. So yeah, loved every minute of mooting. After I finished uni, I also went to the courts, which is, I think, a pretty predictable path for mooters, people that like advocacy. And I'm now a solicitor at the Crown Solicitor's Office, so working for the New South Wales Government as a solicitor there in a variety of matters, but with a heavy focus on court work, which I think is partly due to the mooting background.
Thanks, Angus. And Henry?
So like Alyssa, I did the JD, I think 1 year earlier than her, so from 2014 to 16. And I followed a pretty similar path in terms of mooting. I think I did the torts moot as well. And then started InterVarsity moots with the QUT moot. And also did the IMLAM moot, which is a maritime moot, which is more arbitration. And I did Jessup in 2015, I think. And then after graduation, I went to work for a judge as well, like Alyssa and Angus, on the Court of Appeal. And now, for the last 3 months, I've started as a barrister at New Chambers.
Thank you. And Charlotte?
So I was a Juris Doctor student from 2017 to last year. I only started mooting in the second year, and I did the Public International Law Internal Moot and the Criminal Law Moot. I also participated in this program in my second year, when it's first year running. And I then went and did the Baker McKenzie Women's Moot InterVarsity, and then going on to Jessup in 2019. Since law school, I'm now working at the Australian Government Solicitor, and I'm currently working in a dispute resolution team, so seeing the court side of things.
Thank you, Charlotte. And Joy?
I did the LLB from 2014 to last year. I did the internal moots. I did a lot of internal moots, and it took me a long time to get any good at all. So my technique was just to do them again and again. And eventually I got my break in the form of the women's moot, the Baker McKenzie women's moot. I think in the year before Charlotte did it, and I was lucky enough to get Alyssa as a coach, and I consider that like my break, where I got some good coaching and actually was able to improve a bit more. And from there, I did the Gibbs moot in 2018, which we won. And then I did IMLAM. And since then, I've also done some coaching as well as helped with the women's mooting program. And after uni, I've worked as a grad for a few months in a commercial law firm, but I am about to start at the courts as well next week, actually. So.
Right, great. Well, do you have some questions for us then, Charlotte and Joy? Since we've asked you plenty of questions about torts.
I just had a question about whether you thought your mooting experience at uni helped with what you've done since you finished law school. The skills you've gained, the experiences, the people you've met, that kind of stuff.
Henry, do you want to start?
Sure. No, I think the mooting I did at law school has been incredibly valuable for everything I've done since. I think it's completely inseparable from any success I've had in my career so far. So and you just learn so many different skills that, especially if you want to be a barrister or even just a solicitor doing litigation, they're just universal skills that you can carry throughout your whole career. The main skill out of those I think I've learned is there's no substitute for preparation, and it's always my experience that the more you prepare and the better prepared you are for a moot, you're more likely to succeed, and that's also the case in the real world. So that was definitely the big lesson I took from that.
Angus?
Yeah, I totally agree with what Henry said. I think even just from the academic perspective at law school, I think doing mooting really helps your legal writing because it teaches you how to argue persuasively and also teaches you how to be succinct. And I think when you also transfer to legal practice, you learn that not everyone has those skills, and it will help you a lot. The ability to do that, which is really what mooting is for me. So yeah, it's very important.
I don't have really much to add to that. I think, and presumably if you're doing this program, you're already sold on mooting being something useful to do. Perhaps I'll just add that even while you're at law school, and especially for those of you watching who are in first year or towards the beginning of your time at law school, I found that the skills that I was gaining in mooting were even immediately transferable. This doesn't really answer Joy's question, it's a different question, but were immediately transferable to studies as well, and especially to things like problem questions in exams, because those sorts of skills that you start to learn mooting, putting an argument, actually having to stand up and sit down if you're doing a Zoom moot, argue a case for a client, an imaginary client, forces you into a more creative mindset where you're actually advocating for someone rather than just kind of sitting on the fence. And so I think that's a really helpful change in perspective that you can then take into the way you approach exams as well. Yeah.
I have a question. Do you remember your first moot, and if so, how did that go? And what advice do you have for people who are about to start doing their first moot experience?
Maybe we'll go in reverse order, but and I'll just mention as well that you are welcome to throw in some questions into the chat if you have any questions for us, including for Charlotte or Joy as well. Someone has to be the first person to do that, so feel free. My first moot, I think, was a torts, like the one we did tonight, was a torts moot, and it was in a sort of very small library room, and you get a stack of books and you kind of use it as a lectern. And I think I wasn't very well prepared, and I had too many pieces of, well, I was actually quite well prepared, but I had too many different pieces of paper, which was a bit of a concern because I tried to kind of stack them up on the pile of books, and they sort of started flying around during the moot. And I think at one point I gestured so sort of violently that I brushed the pieces of paper off the lectern entirely, and then had to bend down and pick them up in the middle of the moot, which was pretty embarrassing. And the fairly seemingly smug, very experienced, second year student or whatever it was who was judging, told me that I fiddled with my hair too much. And I don't know, that was really all I remember. And I thought, like, my hair was in my face, so what was I supposed to do about it? But anyway, it was a bit of an intimidating experience. I felt like I was kind of under fire for the entire time, and I didn't even have a moment to string a thought together before another question came. So I think the questions came very thick and fast, and I never really got a sentence out. But it was a bit of a baptism of fire, and I bizarrely enjoyed it despite the horrors. And I was also told that I was directing my submissions I was looking at my opposing counsel every time I made my submissions rather than looking at the judge. So I was trying to explain to my opposing counsel why their submissions were so wrong. And so I was looking at them quite aggressively, I think, rather than just kind of explaining in a neutral manner to the judge what to do. So I guess that's what I learned from it. And in terms of first time starting out mooting, doing this program, I hope, is useful because we're trying to kind of make it a little bit less intimidating to get started. First time advice is pretty much what Henry said before, which is prepare. Even in this program, there'll be some homework tasks and things you can do, and you can read cases properly and don't just extract a single proposition from them and not read the rest of the case. Reading around the paragraph that you're citing at least is always a good idea. So preparation, and look like you're enjoying it, because that always makes you more persuasive. We must be up to you, Angus.
I don't have the strongest memory of my first moot, but it would have been in the torts moot. And back then we didn't have wonderful programs like this. So there wasn't really any intro, and I really had never seen a moot. So I remember just having no idea what was going on. But I think I had the benefit of being a respondent. So you get to see someone, and it's much easier to feed off what the appellant has done and just respond to them. So I think I got off a little bit easy in my first one, but I definitely echo what Alyssa and Henry have said about preparation. I would caveat to say though that I noticed this when I started mooting. Sometimes eager mooters can take it almost too far and kind of try and find the most complex technical legal points in like a torts moot program or an introductory moot program, where they're really not trying to, that kind of veers off the script, and they are meant to be challenging, but they're not meant to be so challenging that you could write like a PhD on it. So if you find yourself going down these rabbit holes and spending so much time on these incredibly intricate arguments, that's also probably not what you want to do. Just kind of try to keep it as simple as possible, and I think that can also put you in good stead for those kinds of moots.
I'll just add to that if you're doing detailed factual research, that's a no-go. So generally with a moot, if it's an appellate moot as well, this is something we'll keep telling you in the program, that the facts that you have in front of you, that they're the facts. So you don't need to go off, and I had someone once who presented me with and this is not me, so this isn't really fair, but presented me with a physics equation about the pace that cows moved at, that they'd calculated based on their kind of research. And the problem is that, it was actually probably a very good argument, and there was, the only reason that you would sort of go, hang on, you can't do that, is because it wasn't in the problem. So you can't kind of go off and extrapolate your own facts and go and research things. You have to just work with what you've got. And sometimes the facts aren't in your favor. So you just have to kind of recognize that and do what you can with what you've got. I just want to add that in. Sorry, Henry.
Yeah. No, that they're really good points. The one about keeping it simple is really good. You're not trying to reinvent the wheel. My abiding memory was that I'd never really done any public speaking or any debating or anything that felt like, for me, that I was prepared to do any mooting. So I was especially kind of not optimistic about how it was going to go. But I think if it gives anyone comfort who hasn't done those sort of things, it wasn't a hurdle or an obstacle for me at all. I think, if anything, if you haven't done those sort of things, it can sometimes be beneficial because you don't have bad habits to get coached out of you. So definitely, if anyone hasn't done anything like mooting before, especially debating, don't feel like that's an obstacle at all. You can still definitely do well. My advice for people doing their first moot, I think one good thing is you can try and watch court or things like this is obviously the perfect thing to watch. To the extent you can find footage of people mooting, that's great. There's lots of these days footage online available of people arguing in court and just sort of getting a feel for how barristers talk and how judges talk and just the sort of rhythm of court. If you can sort of get into that, that's helpful. And also I'd advise you to think of both sides of the argument. I think sometimes you see in moots, you get so obsessed with one side of the argument, you sort of forget the two sides, and as soon as a question gets asked of you, it can sort of be devastating. But as long as you sort of keep a sort of neutral, open mind when you're doing your research, that will prevent that from happening.
All right, anything else? Is there any questions from the chat?
We've got a couple of questions from the chat. Just to jump onto the end of Henry's spiel about video preparation, we've actually got a YouTube page that has a lot of moots and things from SULs and from the InterVarsity competitions, so that's always available there. In terms of preparation, in terms of questions from the chat, there's a couple around preparation. So how long would you aim to spend in preparation, and how would you conduct your legal research?
Well, how long you spend in preparation, from my perspective, really depends on what moot you're doing. But assuming we're talking about not kind of one of the ones where you spend every waking hour preparing, but you know, an internal moot, like a first year moot or a torts moot, I suppose you have to balance it with your other commitments, including your studies, your subjects, of course. I think, well, I over prepared for the very first time and then realized that was probably not necessary. I think maybe, it's very hard to give it depends what you do with your hours as well. It's very hard to give a specific time. I don't know, do you two have any ideas? I mean, it's pretty hard.
I think maybe, yeah, like enough time to understand all of the main cases and to understand the problem. And I think ideally enough time that you could write like your oral submissions out. So you have something to read off. And at the start, that'll probably take longer and then you'll get used to it. So that might be I don't know, a couple of hours. But yeah, it just fits in, I guess.
It depends on if you're doing a moot in a subject that you've done or are doing, and you have, you know, the course outline and you've already been doing your readings for class and things. I would say the course outline is a really good place to start. This kind of goes to the second question as well about legal research. Rather than kind of going off without any sort of structure or thinking that you need to find these brand new cases, the ones in the principles in your course outline, say it's torts, the principles in your key torts textbook and your course outline should be a really good place to start, as well as any cases that sometimes they provide cases in the moot problem, or the pretend judge in the moot problem references cases. So I think you should be able to do that within a few hours, probably. If you already know the principles or the general area of law, then you allow, I don't know, you put 4 hours aside or something. I'm trying to say a number, but it's hard to say. But I think that should be enough time to sort of cover the cases and write some submissions, and then maybe the next, you know, but maybe don't do that the day of the moot, maybe do that a little bit before, so you got some time to, you know, print out your submissions and have a little practice or something if it's the first one. That's about all I'd say on that, I think. All right, is that it?
There's another question in terms of preparing for questions from the bench and how you would approach that.
Henry, do you want to address that one?
Well, I think the best way to prepare for a question from the bench is what I said before, to think about both sides of the argument and think about what you would say if you were arguing on the other side of it, because generally that's the perspective that a kind of hostile judge will come from. And there's really no harm in being conscious of the weaknesses in your argument. There's no side or any moot problem is going to have a perfect argument with no weaknesses, because it's a moot which is meant to be contestable. So you've got to be honest with yourself and honest with the judge about the weaknesses in your case. And some of the most effective advocacy is when you do get those tough questions, without capitulating, just acknowledging that that's the sort of the key issue that you have to deal with, and presenting an answer to the judge that shows that you've thought about the problem, that you've got a way around it that means you can still succeed.
Yeah. And if there's questions that you think are really kind of key, or quite questions you might be likely to get, you can think about, you know, in your oral submission notes, thinking about writing out what you might say in answer to that question. But also the more you can kind of avoid questions or preempt questions by giving the judge, rather than just saying something without an authority or saying something without referring to the facts, the more you can sort of say where you're getting what you're saying from, give the authority for your proposition, then those kind of questions fall away a little bit and you get to make more submissions with less questions as well. All right. Is that everything for, I think we've done pretty well. It's about an hour. So I think, thank you all for coming. I'll thank Sarah and Angus and Henry and Charlotte and Joy. And we're really looking forward to getting to know you over the course of the program. So feel free to contact Joy and I if you have any administrative issues in the next few days. Most of you should have your first workshop this week. We hope you enjoy it, and thank you for your time this evening. Okay, we'll leave it there. Bye, everyone.